General lien. Lien on more than one property of a debtor. A lien is an interest in real property by someone other than the owner. Liens are used to collect on unpaid bills. A general lien is on more than one property. A general lien is on more than one property of a debtor, as opposed to a specific lien, which is a lien on a single property of a debtor. Liens can be voluntary, as in the case of a mortgage or a trust deed, or involuntary, as in the case of a mechanic's lien, judgment, or attachment. Specific liens can include finance liens, like a trust deed or a mortgage, mechanic's liens, an attachment, and a tax lien, and may show up as a lis pendens. A lis pendens is a notice filed at the county clerk that a court action is pending regarding the property and works to encumber a property. A general lien might be an income tax lien or a judgment lien. A general lien is a lien on more than one property of a debtor. Antonyms: specific lien. Related words: lien, encumbrance. Consumer Credit Protection Act of 1968 required lender disclosures to help consumers shop. The Consumer Credit Protection Act of 1968 was the first time that lenders became required to explain their products using common language and terms so that customers could compare one lender with another. The Truth in Lending disclosures are the foundation of the Consumer Credit Protection Act. Title I of the Consumer Credit Protection Act became the Truth in Lending Act, also of 1968, TILA. From this was the Directive Regulation Z. Together, the requirements on lenders include disclosing the name of the lender, amount financed, and finance charge, the annual percentage rate or APR, the total of payments, the payment schedule, and all terms of the loan. Related words: Truth in Lending Law, Truth in Lending Act, Regulation Z. Estoppel. Legal doctrine: prior behavior can't be denied. Estoppel is the legal doctrine which prevents a person from denying the clear implications of his or her actions. The estoppel doctrine is used in agency. For example, if an agent acts on behalf of a seller and the seller allows it, then the agent is the seller's agent by the estoppel. The agency is established not in writing or in discussion, but by actions or behavior of the seller. The seller or principal in this case cannot deny. Quote, stop, sounds like estoppel. This behavior from rightfully establishing the agency relationship. So we call this implied agency, apparent agency, or ostensible agency. In the case of an easement, if the easement is no longer being used by the dominant tenement, the person benefiting from the easement, then the easement is terminated by the estoppel. It's not that the dominant tenement stopped using the easement. It's that the dominant tenement can't stop the understanding that his actions show he no longer needs the easement. Estoppel is the legal doctrine that a person can't deny the implications of his or her behavior. Related words: implied agency. Granting clause. Clause in a grant deed saying title is being transferred. A grant deed must have a granting clause, which is the sentence or statement which says that title is being transferred. It is the granting clause which carries the two warranties of a grant deed, which is that the title is free of any encumbrances and that the grantor has not conveyed title to anyone else. The granting clause is the clause within the grant deed saying the title is being transferred. Property management. Preserve and improve the value of real property. Property managers are brokers or agents working under a broker's license who manage properties for owners who hire them. The property manager's goal is the highest and best use of a property. Resident managers, who are giving reduced rent or other compensation to live in a unit of a 15 or more unit residential apartment complex, do not have to be licensed, but usually work under the direction of a licensed broker who is the property manager. Property managers may manage large residential complexes or retail and commercial properties. Their duties include leasing and maintaining the properties. The property manager's goal is to find and maintain the highest and best use of a property. Related words: highest and best use, resident manager. Quitclaim Deed, title transfer with no warranties of a clear title. A deed is used to transfer title of real property from one person or entity to another. There are different types of deeds: grant deed, gift deed, sheriff's deed, and finance deeds. Finance deeds include the trust deed, all-inclusive trust deed, and reconveyance deed. A quitclaim deed is a transfer with no warranties and full transfer. Quitclaim deeds can be used to clear some title defects. A title defect is some issue which restricts the transfer of property, also called a cloud on title. A misspelled name on a title, for example, is a cloud on title that a quitclaim deed can be used to clear. Not all things that restrict a property transfer are clouds on title. Financing on a property, for example, is a voluntary lien, and even though it can be said to be a form of cloud on title, a quitclaim deed cannot clear financing on a property. The receiver will now become responsible for any liens or attachments. If the property financing has a due-on-sale clause, then the entire amount of the loan will be due upon transfer by a quitclaim deed. A quitclaim deed is a form of title transfer with no warranties and complete transfer. Deed of reconveyance. Deed used when a deed of trust is paid off. So a person buys a house and takes out a trust deed. A mortgage is different from a trust deed. Many states do not use mortgages, like California, for example, because mortgages require a judicial foreclosure instead of a trustee foreclosure. A judicial foreclosure takes longer than a trustee foreclosure, and therefore financial institutions don't like them. In a trust deed, there are three parties: the lender, called the beneficiary, the borrower, and the trustee. The trustee is a neutral third party who holds title, called bare legal title, to the property until the loan is paid. The borrower holds what is called equitable title to the property. Equitable title allows the borrower to use the property normally or to sell or refinance the property. Now back to our story. The homebuyer proceeds to pay off the loan, and when it is paid, the lender instructs the trustee through a request for full reconveyance to give title to the property to the borrower who has now paid off the loan. The trustee will file a deed of reconveyance, and the owner will now hold bare legal title, also called naked title. A deed of reconveyance is a deed used to transfer bare legal title when a deed of trust is paid off. Related words: trust deed. Hypothecation. Buying property with a loan, using the property as security. Hypothecation allows the property to act as security for the loan while the borrower lives in the home. Mortgages and first trust deeds are security-backed loans. The property is the security. Often, however, like with a pawn shop loan, the pawn shop holds the asset as security, so they will be repaid. With real estate, however, hypothecation allows the asset to be kept by the borrower and used by the borrower. Hypothecation is the name for this concept. that the property is security for the loan and the borrower gets to remain in possession of the asset. Tenancy in common. Undivided interest in a single estate. Property owned by a single person is owned in severalty, and tenancy is by an individual. Tenancy refers to how title of real property can be held by two or more people. There are four types of tenancy: common tenancy, joint tenancy, partnership tenancy, and community property tenancy. Note, common tenancy is most often stated tenancy in common. First, community property tenancy is how a married couple holds title to property acquired after marriage and is actually joint tenancy with right to survivorship. Second, partnership tenancy is only used for property acquired for a business partnership. Common tenancy and joint tenancy are almost opposites. Joint tenancy has the most restrictions between the two. Joint tenancy requires all parties become joint tenants at the same time. All parties take title on the same deed. All parties have equal and undivided interest in the property, and all parties have equal right of possession. And joint tenancy has right of survivorship, which is why it is used for community property tenancy. Common tenancy only shares that all parties have equal right of possession. Otherwise, common tenancy is the opposite of joint tenancy in that title can be taken at different times, title can be on separate deeds, and parties can have unequal interests. Generally speaking, joint tenancy is used for married persons and common tenancy is used for flexibility between non-married co-owners. Avulsion. Avulsion is the violent washing away of land. Water is a very powerful force. Water moves land by moving small amounts of dirt, soot, and soil, which eventually can add up to very large amounts. Reference the Grand Canyon formed by water and ice over millions of years. Accretion is when forces like moving water and wind add to a property. Accretion is the natural buildup of soil on a property caused by natural forces like moving water, as in a property which borders a river. Avulsion is the violent washing away of land. Imagine the effect of a flash flood. Imagine the effect a flash flood could have on a hillside. Erosion is the slow washing away of land. Reliction is the extending of land by the natural deposit of dirt and soil by moving water, called alluvial deposits. Reliction results in accretion. It is possible that avulsion could result in accretion if we imagine that the earth, which is violently washed away, is deposited somewhere else on another's land. Avulsion is the violent washing away of land. Related words: avulsion, accretion, accretion, erosion, reliction, alluvium, alluvial deposits.